Okay, in Unit 4, we'll be dealing with liberties, rights, and policies. And so we're going to be looking in the first lecture at civil liberties and civil rights. Now, this is some very dense information with lots of stuff that we need to talk about. And so what will happen is this PowerPoint is extremely long, and I'll try to break it up into more manageable lectures so that you do not have like a 1 hour lecture that you have to watch all at once. I'll try to break it up into more manageable pieces. And so we must begin with this lecture, this unit, understanding what civil liberties and civil rights are. And so we have to sort of think about this a little bit. And anytime that I ask students what civil liberties are, or what liberties are, they say these are our freedoms. And that's not wrong, but we need to really establish what they are more in depth. And so civil liberties are individual rights and personal freedoms in which the government may not interfere. And conversely, civil rights are a protection of citizen equality provided by the government. And so I really think that the best example or the best explanation as to what civil liberties versus civil rights are is that civil liberties are protections from the government and civil rights are protections by the government. And so as we get into this lecture and subsequent lectures, we'll understand that a little bit more and a little bit more. So we're going to start focusing first in the first part of this information. We're going to focus on civil liberties. And civil liberties really have their origins in the ratification debate, the ratification of the Constitution. And so as we've already discussed, the ratification debate broke out between supporters who were known as Federalists and opponents who were known as Anti-Federalists. Anti-Federalists did not like the Constitution because they felt it didn't explicitly protect citizens from the government. Conversely, Federalists believed it did, and that the entire purpose of the document was to protect the citizens from government. And so Federalists said, we will not ratify this until we get an explicit list of rights that we are protected from, and things that the government cannot infringe upon. And so to make it more palatable to the Anti-Federalists, the Federalists agreed to add a Bill of Rights. And so the Bill of Rights can really be called a Bill of Liberties because it created a private sphere of personal liberty that is free from government intervention. So essentially, it created a sphere of protection of citizens from government action. Now, just because the Bill of Rights was part of the national legislature, or excuse me, the national government, it did not apply directly to the states, and it didn't become what is known as incorporated into the states until after the Civil War. And so the Bill of Rights was only applicable at the national level and did not really interfere with the government until the Civil War and the passage of the 14th Amendment that prohibited states from making or enforcing any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive a person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction equal protection of the laws. And so it established, this is the equal protection clause of the 14th Amendment, and it's a big deal because the 13th Amendment passed in 1865 had outlawed slavery, and so you have an entirely new group of individuals who have become citizens of the United States, these former slaves. And so the 14th Amendment is going to be a big deal because it's going to incorporate citizenship into these individuals. And so what happens is the 14th Amendment essentially appears to create a more inclusive society, inclusive of these former slaves, but in reality, it didn't, and the Supreme Court will not interpret the 14th Amendment in this way for another 100 years, up into the 1960s, when we see that civil rights movement really take hold. And so what occurs is the Supreme Court utilizes a process known as selective incorporation, which was the process by which different protections in the Bill of Rights were gradually incorporated and applied to states using the 14th Amendment. And we see this even all the way up until the 21st century. There has been a gradual incorporation of the 14th Amendment onto the states. It wasn't, here's the 14th Amendment, bam, all states must agree to it, all states must abide by it. It was, here it is. It wasn't enforced by the states. States were still disenfranchised groups of people. And it wasn't until a series of Supreme Court interpretation and acts over the course of the next 100 years that states actually started to fully incorporate the provisions within the Bill of Rights. And if we apply it in modern society, we oftentimes think that the Bill of Rights is there, it's all inclusive, we're protected by all of these things, we have unfettered freedoms outlined in the Bill of Rights, but we do not. Everything is regulated. And we do not have inclusive protections. There are some provisions of the Bill of Rights that are areas of unsettled law. They haven't been settled yet. They haven't been interpreted by the Constitution properly yet, and so, or excuse me, by the Supreme Court properly yet. And so we have to sort of do the best we can with these until we get a Supreme Court ruling that sort of settles the issue. And so that's sort of what we're going to be looking at. And so as we look at our civil liberties, we're going to examine some very specific amendments to the Constitution. These amendments that protect our basic freedoms for us, and we're going to do that by looking at specific provisions within these different amendments. And so we're going to look first at the First Amendment. And we should know by now that we have the freedom of speech, religion, press, petition, assembly, something you should have been taught a very long time ago. But understand that nothing is absolute. You do not have unregulated freedoms, and everything has a limit. So we're going to talk about that for just a moment here. So if we turn our attention to the religious clause of the First Amendment, we have a couple of clauses in the religion aspect. Clause number 1 is called the Establishment Clause. And it says, quote, Congress shall make no law representing an established religion. And then we have another clause called the Free Exercise Clause that says, or prohibiting the free exercise thereof. And so we need to look at our interpretations of these clauses. So if we look at the Establishment Clause, we have different interpretations. The first interpretation of the Establishment Clause was the one that the authors of the First Amendment, the Founding Fathers, really intended for the Establishment Clause to look like. And it was that government is prohibited from establishing an official religion or church in the United States. We had just separated from England, and they had an official church, the Anglican Church, and others were not always free to practice a religion as they saw fit. And so they were persecuted religiously, and as a result, there's going to be individuals that flee from England, the Puritans. They're going to go to Holland, and then they're going to move on to the colonies so that they can practice as they see fit. And so they didn't want to have any infringement upon being able to practice in the method that they wanted to practice. And so with that, the founders said the government cannot create a national church that we all have to worship in. The second interpretation is that the government should not take sides among competing religions, but may provide assistance to religious institutions or ideas as long as it did not show favoritism. And so it's saying that the government can interact with religions as long as it does so equally. It cannot choose one favorite over another and try to exercise that on other people. And so can't take sides, but you can provide assistance to religious institutions. And then the third interpretation that we are probably most associated with, the thing that we've probably heard before, is the most commonly held interpretation today. And this is that interpretation of, quote, the wall of separation between church and state that was championed by Thomas Jefferson. There shouldn't be a mix of church and state. There should be a wall that separates those two items. And so Thomas Jefferson, the Jeffersonian democracy, really championed this idea, and it is something that we have struggled with all throughout our nation's history. But understand that nothing is absolute. I've said that before, I'll say it again. And so we do see some bleeding over of government into religion and conversely religion into government. But the interpretation by the Supreme Court has been relatively restrictive on religion and government and vice versa. And one of the most restrictive areas is the idea of religion in schools. And so school sponsorship of things like a moment of silence or non-denominational prayer is highly suggestive of school sponsorship of a religion in violation of the Establishment Clause. And so since education, schools are an arm of the government, then they cannot sanction or engage in these types of things. But it has been permissive, however inconsistent, in public displays of religious symbols by cities. And so it's been very restrictive in one area, more permissive in another. And this inconsistency of public displays of religion can really be summed up by looking at two 2005 cases by the Supreme Court. Number one, called Van Orden versus Perry, which was a 5-4 decision, and McCreary versus the ACLU of Kentucky, which was a 5-4 decision. Both of these were decided by the Supreme Court. And in both cases, it dealt with a display of the Ten Commandments on government property. Van Orden versus Perry, Texas displayed a Ten Commandments on the Texas state capitol. In McCreary versus ACLU, Kentucky displayed the Ten Commandments inside 2 courthouses. In Van Orden versus Perry, in the Texas case, the Supreme Court ruled that it was not a violation of the First Amendment to display the Ten Commandments on the state capitol. But in McCreary versus ACLU, the Supreme Court suggested that it was a violation of the Constitution. And so we have some inconsistency, it seems. But just like with most things in law and in government, you have to look at the nuances. And so the case was really decided based on the question, what was the purpose of the display? Not that it was displayed, but what was the purpose of the display? And so it was decided that in the Van Orden versus Perry case in Texas, the display was of a secular purpose because the Ten Commandments were displayed as essentially a display tied to the development of law, and it was displayed with other important law codes throughout history. It was secular. It was showing the evolution of law throughout world history. And the Ten Commandments is going to be one of those early law codes. Then you have things like, well, you have the Hammurabi's Code, and then you have the 12 Tables of Rome, and then you have a lot of other things that has helped to shape law into modern day. But in the McCreary case, it was purely for a religious purpose and had been constructed very recently and had been constructed all by itself. But this just demonstrates the idea that this aspect of the law is really unsettled. It's not settled. It's very piecemeal in its approach, and so we don't have a settled law in regards to whether or not it's okay to display these types of things. And then if we look at the interpretation of the free exercise clause, we have a Supreme Court case called West Virginia State Board of Education versus Barnett. And in this case, a Jehovah's Witness family refused to salute the American flag because it violated their religion. And these individuals were at a school. They were children, they were school children, and they were suspended from school for not saluting the flag. It was taken up by the Supreme Court, and the Supreme Court decided that even if it were offensive to others, these actions were protected under the Free Exercise Clause. These individuals were exercising their own religion, and so the state could not infringe upon these individuals in their exercise of the religion. And so students are not required to salute the American flag in regards to a religious exemption. And so that's going to be decided by this case, West Virginia State Board of Education versus Barnett. And then we have another decision called Holt versus Hobbs, which was dealing with a Muslim prisoner in jail in Alabama. The dress code in the Alabama prison suggested that individuals were not allowed to grow a beard, but this individual suggested that a beard was part of his religious practices, and his inability to grow a beard disallowed him to practice his religion properly. And so it was ruled by the Supreme Court that this was a violation of the Free Exercise Clause. And so they are very protective of individuals. The law and the Supreme Court is very protective of individuals intending on practicing their laws. It was, in both situations, it didn't really hurt anybody else for these individuals to practice their laws the way that it did. It may have been offensive to somebody, but it did not cause harm. And so decisions were made to allow them to practice as they saw fit. All right, so I'm going to stop this lecture here. We're going to continue in the next lecture dealing with free speech, and that is a whole nother situation, and so I don't want to go too long. I want to make these manageable for you to watch and to listen to, so I will see you in the next lecture.